To move on extreme urgent matter relating to violence at Murshidabad yesterday, different candidates of our one particular political
File it. It will come as per presentation form.
Presentation form.
Yes.
Under extremely urgent situation.
Today is not the mentioning date. Mention on Monday.
Kindly here, I'm praying for leave, my lord. But the situation is that at Behala Thakurpukur, the coming election is on 29. The petitioner of your lordship has raised allegation against two anti-social elements who are storing and procuring arms in front of the club of the house of the petitioner. He has protested against that. He has been assaulted, mercilessly assaulted. He fled away.
When assaulted?
22nd, my lord, day before yesterday. He made the representation. Police has not considered. Election Commission has been made the served the representation. None considered, my lord. I am before your lordship, my lord.
Yes, file it. It will come as per presentation form.
But in after 3 days,
he is a candidate, contesting candidate.
He is protesting that in front of his house.
Very well. File it. It will come as per presentation form. Sorry. There's no further mentioning. It's not a mentioning date.
Subject to the.
Sorry. Sorry, it's not a mentioning date. Yes.
My matter is pending before this court for last 4 months. The police is not obeying the High Court order and also the lower court order, and the majesty of the judiciary is being challenged because in nexus with the respondents and the police, including the CP was also involved in also. They have already disobeyed 3 times.
What is the urgency?
Urgency that the police has in nexus with the.
Very well. It's not an. I am not convinced with regard to urgency. Let it continue in the list.
Can I just submit with all the papers? You can have.
Sorry. Yes. Please call the list. Let it appear in the list. I cannot upgrade. Please call the list.
Jalpaiguri matter item number 1.
Please don't take it. Please don't take it. I have heard you. I am not convinced with regard to urgency for upgradation. Yes.
Jalpaiguri matter item number 1.
My lord, I beg to appear on behalf of the applicant, my lord. Am I audible, my lord? Am I audible, my lord?
Yes. Who is for the petitioner?
My lord, I am for the petitioner. Am I audible, my lord?
Yes, but the different advocate mentioned the matter yesterday. Where is he? Where is that advocate who mentioned this matter in view of urgency? Yes?
My lord, I do not have any instruction, my lord.
Where is the learned advocate who mentioned yesterday?
My lord, as per my instruction is that the order has been complied with.
The learned advocate who mentioned the matter, where is he? You did not mention the matter. I remember yesterday.
Yes. My lord,
yes, perhaps you mentioned the matter. Oh. Why it is? Oh, it's a CPN matter. Right. Oh, Jalpaiguri, bolbe to.
Jalpaiguri bench. My lord, I beg to appear on behalf of the applicant, my lord.
Yes.
My lord, as per my instruction, my lord, order dated 21st of July 2025 has already been complied with.
All the matters 1 to 5 are similar matters.
1 to 5 are similar matter passed by your lordship, my lord, dated 21st of July 2025, my lord.
So special land acquisition collector has passed an order.
Yes. Reasoned order has been passed, my lord.
Issue. At the time of call, learned advocate representing the applicant submits that the order passed by this court on 21st July 2025 on the connected writ petition is complied with. Stop. Next paragraph. In view of such submission made on behalf of the petitioner, contempt application is disposed of and contempt proceedings stands dropped. However, this order shall not preclude the petitioner to take steps in accordance with law. Parties to act on the server copy.
My lord, names may
one
be
after
recorded.
Another, not at the same time. 5 matters are to be disposed of separately.
My lord, names may be recorded, my lord. Names may be recorded. Debanjan Das, led by Mr.
Item number 2.
Yes.
I'm
Names may
providing
be
the
recorded,
names.
my lord.
Yes, yes, Debanjan Das.
Led by Mr. Shubinoy.
Led by,
Shubinoy Deve, my lord.
Mr.
Lord, I'm
Shubinoy.
providing the names.
led by,
Shubinoy
Shubinoy.
Deve, Mr. Shubinoy Deve.
where is he?
My lord, he's the advocate on record.
Maybe, but where is he? If he does not appear, then sorry.
My lord,
Yes.
Debanjan Das.
আচ্ছা আগের অর্ডারটা দেখো তো 27 জুলাই 21 জুলাই 2025 ছিল তো হ্যাঁ সেম অর্ডার disposed of. Next.
Item number 3.
Last occasion why you did not appear, I had to adjourn the matter.
Yes, my lord.
Yes, 21st July 2025 order disposed of. Record names of the learned advocates. You are appearing for?
For the petitioner, my lord. Mr.
My lord,
Das is
with me. With me.
So record his name also. Yes, next.
Item number 4.
Yes, 1st July 2025 order disposed of.
Item number 5.
Twenty-first July 2025 order disposed
Complied.
of. Same order. Yes.
I am much obliged, my lord.
Grateful.
Item number 1 from principal bench.
My lord, on 17th this month, my lord.
Who is for the state?
For the state led by Mr. Shen, Mr. Amol Shen.
Then means
Mr. Amol Kumar Shen, the learned
yes,
AS.
he is there. Yes.
It is. My lord, on 17th, my lord, the petitioner was picked up from his office. My lord, by
Residence or office?
the office and residence. He was in his office. And he was in the
Use microphone.
He was in his office, my lord, when a few persons from the Falta police station, allegedly they are from the Falta police station, along with some of the local hoodlums, my lord, they all came to the residence and the office of the petitioner, and he was asked to accompany them. The petitioner was dragged into the car. Well, we have the CCTV footages as well. We're ready with the footages. Petitioner was dragged into the car and was being taken to an undisclosed location. Not
By
to the
whom?
police. By some of the hoodlums, my lord, in civil dress. There was no police. 2 police officers, 2 or 3 police officers were there, and few of the local hoodlums and the political leaders.
So police personnel as well as local hoodlums.
Yes, my lord. They all came
Jointly
together.
picked up the
Jointly. They came to the petitioner's residence, my lord. Victim was being taken to some undisclosed location. When the petitioner understood there's some ploy behind its being picked up, he started to shout. Sticking his head out of the car, he started to shout. On 17th. He started to shout and drag the attention of the local. Then he was taken to the police station, entered through the back door, taken to a first floor room, and he was being locked up there.
in police station.
In police station, the CCTV covers the front portion. He was taken through the back door, taken to the first floor where there is no CCTV. There is the offices and the CCTV operator room and the kitchen is there. He was being locked up there, thrashed, threatened not to come out of his house. And after the elections, if the ruling political dispensation of the state comes back, his house will be burnt. His children will be dragged out of the house. His house will be bulldozed. And if he comes out and attends any political meeting, or he comes to vote. When he asked, what's my fault? Why have you dragged me to the police station? He was saying there is a FIR against you.
being police station, the Falta police station case number 81. Under what section, what was the offense, who was the complainant, what was the complaint, these were not disclosed. Well, none of the police officers were wearing the name tags. No arrest on inspection memo was given. He was detained. He was beaten up till 11 in the night, my lord, and then released.
17.
17 itself. My lord, when he tried to, 17th was a Friday, I believe. 17th was a Friday.
Yes, carry on.
Yes, my lord. The next day, he tried on my lord, the Monday, my lord, he tried to go to the court to find out whether there is an FIR against him. Well, he saw, what was most surprising, my lord, he saw that FIR number 80 came to the court. Well, the FIRs have to be transmitted to the ACJ within 24 hours. My lord, he went to the court, my lord, to find out. His personals went to the court. He did not personally go, my lord. His personals went to the court to say whether any FIR 81 has been caused against him. He saw FIR number 80 was there with the GR. 82 was there with the GR, but there was no FIR of 81. This blank space was left in the GD copy, in the GR copy, my lord. The GR register. Well, he doesn't know what is his offense. Why has he been picked up? What was the complaint against him? But till date, he could not ascertain. He's just being threatened that he will be taken.
Where is your complaint?
Well, the complaint is page 18.
It's an advocate's letter.
Yes, my lord. He was, my lord, he's not, cannot read and write. When he called up his advocate in Kolkata, my lord, she has, my lord, forwarded this letter. Well, he just wanted to take, my lord, if there is any complaint against him, he wanted to take the legal recourse. He's being threatened that he will be implicated in more than one case, or one after the other.
So petitioner is praying for pendency of criminal proceedings against him. How many?
Yes.
And till election, he is praying for protection in view of the incident which took place on 17th April. So let there be an assistance to the petitioner since suddenly he has been.
Me actually. Now, my lord, this is my lord, the police report. Now, my lord,
No, yeah, whether the police report contains a list of cases.
yes, the list of cases pending against him, and including that, my lord, that case number 81, that yes, case number 81 also, and what happened on 17th April, that was also.
Just a minute, I will hear you.
There a copy. Okay, now. Thank you. Many things can be said on oath unless it is oath versus oath.
Video. Ready আছে খোল আমাদের ভিডিও আছে ওই টাইমে ভিডিও বানাচ্ছি পনেরো 7:30 পনেরো কনফিডেন্সটা করতে
আর বড় কি কোনো দেখা
Yes, Milord.
I have the.
There are
seen this.
three,
Yes.
including, please. There are three matters which are pending, out of which one was in 2021, another is in 2022, and last one is filed on 2015, 15th of April 2026. This is the last police station case number 81 of 2026. So it's not a new matter, and you are the FIR named person.
Yes.
He was taken to police station for interrogation.
Well, may I show this? Well, the time is time of offense, Milord. Can you see the date and time
Sure.
of offense? Will kindly allow
Yes,
this?
yes.
Will kindly have the CCTV footage always in another place?
Yes, yes.
Will kindly have a look? Milord?
Affidavit of service filed on behalf of the petitioner is taken on record.
Will kindly have a look?
Next
Will kindly
matter
allow
is
the
hard in
Can be
presence of the
placed
law
Milord,
representing
before
the
the
petitioner
court
and
where
state
he may pay
respondents.
for bail or
Next
anything.
paragraph. There are two other criminal prosecutions, 21, 22.
These are all politically motivated.
You
Milord,
take steps, you approach the jurisdiction
kindly gives you protection
Yes.
till the time.
Not the record.
Nothing.
Record cannot.
Milord, for my head, Milord, only for my life, nothing else. Well, I'm not seeking a protection against
On
arrest.
17th April,
Repeatedly
it is
said no.
alleged by the learned
Court
advocate
cannot
representing the
give this
petitioner.
type of protection.
On 17th April 2026, petitioner was suddenly picked up from his residence, office, and suddenly picked up from his place and was taken to police station, which prompted the petitioner to lodge a complaint, which prompted the petitioner to approach this court with the present writ petition, seeking necessary direction upon the concerned police authorities for providing assistance. Stop. It is also prayed for in this writ petition that prayed for in this writ petition for a direction upon the concerned police authorities to provide list of criminal prosecutions pending against the petitioner. Next paragraph, Mr. Amol Kumar Sen, learned additional advocate general, appears on behalf of the state respondents and files a communication dated 23rd April 2026 of Inspector in Charge, Falta Police Station, Diamond Harbour Police District, along with certain documents, and same is taken on record. Stop. Copy of the said communication dated 23rd April 2026 is made over to the learned advocate representing the petitioner. Next paragraph, it is submitted by Mr. Sen it is submitted by Mr. Sen that there are three criminal cases, criminal prosecutions pending against the petitioner as disclosed in the communication dated 23rd April 2026. And the last one is Falta PS case number 81/26 dated 17th April 2026 under certain provisions of BNS and section 27/25 of Arms Act. Stop.
All are cognizable of it.
Yes, Arms Act. Stop. In view of disclosure of particulars of criminal prosecutions pending against the petitioner, one of the prayers couched in this writ petition is found. One of the grievance ventilated in this writ petition is found to be redressed. Next paragraph. With regard to stop. It is next paragraph. It is also disclosed in the communication dated 23rd April 2026 that petitioner was taken to police station on 17th April 2026 for interrogation.
He was called for interrogation. Third paragraph, last but one sentence.
Sentence table poro.
And his statement was recorded.
Right. No, on 23rd, on 17th April 2026, investigating officer in Falta PS case number 81/26 dated 17th April 2026. Visited the place of occurrence and examined available witnesses under section 180 of BNSS. Stop. In addition thereto, it is also disclosed that petitioner was called for interrogation, and statement of the petitioner was recorded in connection with Falta PS case number 81/2026. Stop. Next paragraph. In view of the next paragraph, therefore, the allegations made by the petitioner against the police authority found to be not substantiated. However, not substantiated. Stop. Next paragraph. In view of aforesaid scenario, the writ petition stands disposed of. However, police authority is directed to maintain peace and tranquility at the local and keep vigil. This is your urgency.
Milord, I'll indicate, Milord.
That with leave matter
Milord.
was mentioned and it has to be taken up. Otherwise, he will be killed by Monday. This was the mentioning. That's why I am aghast to mentioning, especially in this determination. This was mentioned that it is very urgent. Then I asked him that he is a political leader just before, or political personality that just before election it is required to be heard. Yes, he is associated with a political party. Now thereafter, yes, you mentioned, you know the system of my court, that if you file a writ petition indicating the date when it is date of indicating the date in the presentation form, as per presentation form it will appear. My lord, by Monday, if it is not taken up, then something will happen to the petitioner.
That's
and this is the case which is coming out before this court, that from 2021 there are 3 FIRs.
Milord, from 2021, Milord, these are only for Milord.
That's why
simple
court
hurt.
has started disbelieving lawyers,
These are simple hurt,
especially in this determination.
By hook and crook from writ court.
I told him
An order is
that you
passed,
mentioned
and
today no
in-
leave is necessary, matter will come up on Monday. No, my lord, kindly consider this.
just to obtain a bail in other way.
Yes.
Through writ.
I never prayed for a bail, Milord.
What is the charm in getting leave from this court? I do not know. Only one thing I know, because I was on that side for a long period of time, it is easier to get the matter filed.
Get.
But if you do this, you are a junior member of the bar, court will consider, court will remember you.
Milord,
And in future, clients will come, clients will go, but the court will remember. There are certain advocates, words from them is sufficient so far courts are concerned. That yes, there is a genuineness. For one person, for one matter, don't lose your credibility, because you will be in this institution for a long period of time. Yes, please call the next matter.
Item number 2.
Here on behalf of the petitioner. On last occasion, the respondent number 5 is supposed to provide the report.
Lordship, I beg to appear for the petitioner.
You are for the state. Who is for the state?
I am for the status.
You are for the state.
Lordship may be permitted to appear on behalf of the petitioner on live streaming.
Yes, yes. You are appearing for the petitioner?
Yes, Lordship.
Yes. Yes, report.
May I hand up to you, my lord? Iqbalpur PS Senior Instruction Report.
It's not a report. It's a communication to you. Sorry. When court directed to file a report has to be filed, not in this fashion.
All officer engaged in
25th
election
March,
with you, my lord.
25th March. Don't try to be too clever before this court. I filed this matter. I'll direct the Iqbalpur police station officer in charge to remain present tomorrow on Monday at 10:30.
I'll inform, but previous OC are transferred to other.
I filed, passed an order on 25th March 2026, and this is a communication dated 25th March 2026. Today we are on 24th of April, and you are filing the same thing.
My lord, kindly 2 days accommodation, my lord.
You are filing the same thing. You are trying to outwit this
No,
court.
my lord. Last
In this
occasion,
fashion. You could have prayed for time that I have not received any report.
kindly make a not today, my lord. At least 2 days accommodation, my lord, kindly.
You could have prayed for time. I generally accommodate all the lawyers. And this is
Lordship,
the
may I-
performance that I passed
Lordship-
an order on. Please wait. I passed order on 25th March 2026. And on 24th March 2026, this formal communication to the learned government period, that is you are placing in terms of the order dated 25th March 2026. You are not only an advocate of the state government, you are also officer of this court.
Pardon, my lord.
Then I have to direct the LR that this is the performance. And I'll direct the LR to file a affidavit that why this is being happened before this court. Take it back. Issue.
Lordship,
At the
may I
time
be
of call, at the time
Lordship.
of call, learned advocate representing the state respondents has filed a writing, thereby submitting that this is a report in terms of the order dated 25th March 2026. Stop. However, on perusal of the said writing dated 25th March 2026, it does not appear that this is a report of the inspector in charge of Iqbalpur Police Station, Kolkata, in terms of the order passed by this court on 25th March 2026. Stop. The writing dated 25th March 2026 is returned to the learned advocate representing the state respondents. Stop. Iqbalpur Police Officer Inspector in charge, Iqbalpur Police Station, being respondent 5, is directed to file a report strictly in terms of the order dated 25th March 2026 by 7 days from date, failing which appropriate order shall be passed, ensuring personal presence of the inspector in charge, Iqbalpur Police Station, on a subsequent date. Next paragraph. Next, learned advocate representing the petitioner and advocates representing the petitioner and state respondents are directed to communicate this order to the inspector in charge, Iqbalpur Police Station, by 2nd April. No, sorry. Today we're on 24th. By 28 April 2026. Communicated.
Lordship, only one difficulty.
Next matter.
Lordship, only one difficulty is there.
Item number 3.
I permit the learned state advocates to rely upon the communication. It does not mean that when the court will direct the concerned police authority to file a report, then a communication is to be placed before this court, and that is backdated when this matter was heard. In one matter, learned advocate general was appearing before me in connection with the process and meeting issue, and learned advocate general, having seen that it's a communication, requested this court to permit him to take back this communication and prayed for time to file a report, formal report. That should be the approach. At least the matter under the same heading for further consideration on 12 May 2026. Next.
Item number 3.
Not today.
4.
Lordship, I am appearing on behalf of state lordship in item number 4.
5.
Other side?
Mr. Shumon Sengupta was
Not today.
6.
Not today.
7.
Yes, 7. Other side? Not today.
8.
My lord, I'm for the state.
State. Not today.
9.
8. You are for the petitioner? Yes, come forward.
Item number 8.
Six.
6 is over. I have
6, my lord. 6, I am for the petition.
Yes, yes. Item number 8 I have called.
My lord.
Yes.
Private respondent number.
I have made it not today. Come
no.
back on Monday.
No. She is appearing for respondent number 6.
6 for the petition.
Over not today. Come back on Monday.
Sujit,
The side was not there.
Other side is there.
Both sides are present. I am taking up this
My
matter.
lord,
Come back
here-
on Monday. Come back on Monday. Yes.
Here, my lord, I wish to give boundary wall.
Yes.
to my
Yes.
land. But the private respondents are obstructing. I purchased the land from the respondent number 6, my parents. Now the land has become valuable. Naturally, others would encroach. So I want to give a boundary wall. Now they are obstructing the private respondents. That is the plain and simple matter.
So what police authority will do? Approach the civil court.
Police, my lord, will see that.
Will decide that whether you have a right to
No, no,
erect the
no,
boundary
no,
wall or not.
No, only, my lord, no breach of peace takes place. Nothing more, nothing less.
Mr. Sujit Bhuya for the respondent number 6. He is stuck in village Paschim Manipur, cannot attend the court, my lord.
Yes.
He is went for the vote to Paschim Manipur, but insufficient vehicles, he cannot attend the court, my lord.
So, well, that is the only simple issue.
গন্ডগোল হয়ে গেল 6 8 ও আবার বলছে অ্যাপিয়ারিং ফর দ্য 6 আই থট হি ইজ অ্যাপিয়ারিং
Yes,
ইন
yes.
আইটেম নাম্বার 6
My lord, in a hurry.
total topsy turvy situation.
My lord, the petitioner.
Just a minute. Just a minute. Thirtieth April. Next.
My lord, kindly accepting 30th on any.
You have difficulty on 30th.
Accepting 30 on any.
7th May.
Yes. Yes. I am grateful, my lord.
Item number 9.
Come back on 7.
Yes.
Item number 9. Lordship, I beg to appear on behalf of the petitioner.
Yes. Dautu.
There are certain Lordship private respondent.
Private respondent.
Not there.
So therefore, I'm 30th April. All matters cannot be fixed on Monday. Otherwise, it will be difficult.
As per you, Lord.
30th April.
30th April. Grateful to you.
Item number 10.
I'm for the petitioner, Lordship.
30th April.
30th. Grateful to you.
11.
Lordship, item number 10 can be not today, Lordship, because it will be infructuous, Lordship.
Yes.
It will be infructuous. On 30th, it will be infructuous. Can it be on not today? Only not today. Item
10.
number 10, Lordship.
Not today. Item number 10 টা not today করে দাও, not today চাইছে।
Grateful to you.
Item number 11.
Item number 11, kindly make this matter after 27th April.
27th. Very well.
After 27th.
30th April.
Okay, great.
May. Why after 4th? Are you contesting election? You will wait till counting.
No,
Then?
I voted for casting vote on 29.
Yes. 29th will be the Wednesday. So you will come back on the next day or day after tomorrow or after 2 days.
Next day, 30. I will not return. That's why I'm saying after 4th.
So 30th you will have difficulty. Very well on 6th May.
Item Item number 13.
Not today.
14.
Not today.
15.
I will state 15.
Lordship,
15.
Lordship, I am for the petitioner. Mr. Mighty was here. He just one matter has been called up. He can give us very short pass.
Not today.
My lord then keeps it on Monday because on
Not today, I've
no,
said.
in Tuesday, Monday he has 2 NIA matters prefixed, and kindly keeps it on Tuesday.
Very well, 28 April.
Grateful, Lordship.
20th April. You are also representing the private respondent. Petitioner. Not today.
Item number 16.
Petitioner.
I am for the statement.
Private respondents are there.
Not today. On 30th April.
Item number 17.
Not today.
79 for the petitioner.
Other
18.
side. Not today. 18. Why?
For the private respondent.
Where is he?
He's on the way.
He is on his way.
On his way.
Not today.
My lord, kindly
19.
Tuesday, my lord. Can it be fixed on Tuesday?
30th April.
19. No, 18.
Item number. Please wait. I'm on 18. Please wait. Yes, 18. 18 who is? What is your difficulty?
Monday, I have another matter.
You have difficulty.
Yes, my lord. Can it be
30th April. 30th April. Yes.
grateful, my lord.
Item number 19.
I'm sorry, my lord.
Yes.
I'm appearing for the private respondent in item number 9.
Who is for the petitioner?
It's not that.
30th April.
As your lordship pleases. Grateful, my lord.
20.
My lord, I am for the petitioner.
Other side.
My lord, I have served.
30th April.
My lord, there is just one difficulty. I have served the private respondent also, but it is showing addressee is absent.
Very well. On 30th April, let me see what will happen. You will get more time. 4 or 5 days time. Yes.
21.
I am for the private respondent. I am for the private respondent.
Not today. 30th April.
30th.
22.
30th April.
23.
Lord, I am for the state.
Petitioner. 30th April.
24.
30th April.
25.
30th April.
26.
30th April.
27.
30th April.
28.
30th April.
29.
Same 30th April.
30.
For state.
You are for the state.
Yes.
30th April. Other side is not there.
31.
30th April.
32.
30th April.
33.
Supreme for a short pass over.
No. 30th April.
34.
30th April.
35.
I am for the private respondent.
30th April.
36.
30th April.
37.
Same 30th April.
38.
38, I'm for the state lordship.
Petitioner.
Your lordship, this is my affidavit of service.
You are for the petitioner.
Yes.
Go to. Then there is no use of taking up this matter. 30th April. Come back.
Item number 39.
No. File it on the next day.
Okay.
Yes, next.
Item number 39.
30th April.
40.
30th April.
41.
30th April.
42.
Same 30th April.
43.
In item number 43, Lordship, I beg to appear on behalf of the petitioner. Lordship, petitioner is a contesting candidate from Kamarhati Constitution Assembly, Lordship. He was the former MLA of that constituency, Lordship. Now he is contesting election for the CPIM this time,
Yes.
Lordship.
Yes.
Now, Lordship, he is seeking some police protection for his personal, Lordship, for the
Well, Monday.
on Monday, Lordship. Can it be taken up Monday? in upgraded lordship, I can give a notice up to the, because otherwise it will be infactual lordship, that ensuring election will be on 29th
Well,
lordship.
it will be the first matter on Monday.
Grateful to your lordship.
Item number 44.
Not today.
45.
Not today.
46.
30th April করবে যেগুলো নট করছি, মানডে রাখবে না।
46 I am
46.
petitioner, man.
Petitioner. Other side,
I have served, my lord, affidavit of service.
30th April.
Grateful.
47.
30th April.
48.
I am for the petitioner.
Yes.
Let it be my next week. Because state is there, private respondent is there. So, my lord,
You are appearing for
Private respondent.
state. Who is appearing for the state, Mr. Banerjee?
I don't know the name of the council, but they're not appearing. Let it be next week, not Tuesday.
There is
or
no
30th
urgency.
anything.
There is no pressing urgency.
Urgency, I am praying for Tuesday, my lord, if it is possible.
No, in that event, let it be on 6th of May.
Lord, I tell you, Lord, what is the fact, my lord? They are excavating, my
For the
lord,
respondent number 3.
3. But my lord, Mineral Development Corporation and the state are to be there because it's regarding my lord, mining of sand, where there's an interim order by the court restraining the private respondent from taking away the sand. They are
6th
taking it
May.
away.
6th May.
Lord, in the
Many
meantime, they
matters
will
are
continue.
fixed. Many matters are fixed on by this time.
Tuesday it is not possible.
No,
because
no,
they are
it will not be
continuing-
possible.
They are continuing with the, my lord,
Then do the matter.
excavation, my lord.
Then do the matter
There's an
today.
interim order.
Then do the matter.
Yes, I'm ready with the matter, my lord. If your lordship,
Who is for the state? You are appearing for the state.
I am for the respondent number 3.
Are you appearing for the state? বুঝো তাহলে কারো হয়ে দাঁড়াচ্ছে তাই জানে না। Respondent
No.
3. Are you appearing for the
Well,
state?
Yes, sir.
তুই জানে না। বার করো না ফাইলটা, কোনো লাভ হবে না। She is not for the state.
is not for the state, my lord. 3 is, my lord, the
You are practicing in High Court, you do not know on whose behalf you are appearing.
Sir,
Is it for the
my
private
learned
respondent or
senior
state?
advocate today is not present.
Then why you are appearing if you do not know anything?
they are for the Mineral Development
Not
Corporation.
today, sir.
The chairman, West Bengal Mineral Development Corporation. So the state has to be there, my lord.
আর ও চাইছে আজকে না করতে, করে অন্য দিন করতে। Yes, chairman, West Bengal Mineral Development
Mineral
and Trading
Development
Corporation. So you should at least submit that you are appearing for Mineral Development and Trading Corporation. Don't you attend the chamber of your senior? Only appearing before
I
the
have
court.
no
I am for
instruction
respondent number
about
3.
this case, sir.
And this is the assistance court will get from the members of the bar.
অসিত বরণ দে।
With Bhavan, there is the petitioner, name of the
Respondent
petitioner.
number
No,
3,
if matter
sir.
is taken up on 6th May, what will be
Lordship,
the difficulty?
Mr. Haldar is
Please wait.
Let it be on 6th, my lord, because
No,
they
what
are
will be
doing
the
some-
difficulty? Mr. Banerjee,
So
please
difficult-
tell me.
They are, my lord, they are excavating and carrying away the sand, which is restrained by the civil court, affirmed by the Honorable High Court. It is a sand block where, my lord, lessee has given us, my lord, the permission to lift the sand, purchase the sand. We have purchased. Now, my lord, the private respondents are taking away the sand, which is not affecting our interest because we have purchased the sand and they are restrained by the interim order not to, my lord, take away the sand. They are doing the mischief. We have requested the police, they are not helping us. This is the case. So we shall come back on 6th.
No, you have purchased this already. You have purchased the sand.
Purchased long back. After that, my lord, they my agent, my lord, started taking away the sand. I repudiated the agency and told them not to give it to him, but they are continuing, my lord.
Therefore, in terms of the order passed by this court and the civil court, the agents are not permitted to take.
Not permitted. Not
the
permitted,
sand.
my lord. No,
Not,
not
but they are
permitted.
lifting. But they are lifting.
lifting. Yes. And I know I have a remedy under order 39 rule 2A, but that is not for contempt, for violation. But if not this mischief happens in the meantime, that not becomes irreversible if they take away the sand. That is why I am before your lordship. Only for limited protection that this is
Very
not-
on 30th April.
I'm deeply obliged, my lord. I'm deeply obliged.
Because state has to be hard in
Mr.
that.
Haldar is appearing this matter, my lord. 38th April he will appear, my lord.
My lord. We shall come back on 30th.
Whether Mr. Haldar has come today.
No, not, my lord. He's not in court.
30th April.
30th. My lord. I'm grateful.
Item number 49.
April
50,
30th April
51,
30th April
52,
other side 30th April
53,
30th April
54,
same 30th April
55,
30th April
56,
30th April
57,
30th April
58,
30th April
59,
30th April
60.
30th April. Yes, Mr. Maiti, anything you want
I beg to be excused, my lord, that item number 15 was there, my lord. Another matter was called on before the Honorable Justice Hitobroto Chokro, my lord. My lord, just, my lord, I asked my junior to take a pass over, my lord. Your lordship has been pleased to, my lord, fix it up on, my lord, Tuesday, my lord. My lord, difficulty is Tuesday, my lord. I am appearing in the special PV for the NIA code, my lord. That is for framing of charges, my lord.
Item number?
Item number 15, my lord.
15.
My learned friend is appearing for the state. If your lordship is so pleased, my lordship can take up the matter, or
No, if he is appearing, place
yes,
your case.
my,
If there is no other private respondents.
my lord, private respondents are
Yes,
there.
you are appearing for?
My lord, they have to serve the copy of the state. They was not found the to serve
I cannot hear you. Please louder, please.
Item 14.
14, no, this is 15.
Ma'am,
Lord, super 15 is confirmed.
15 days out.
15.
8946.
Lord, so far as private respondent is concerned, my lord.
There are private respondents.
Yes, my lord. We served, but everything has come back. My lord, though they are proper parties, my lord.
Most of the
Your
matters there
main
are private
grievance,
respondents.
your main grievance is against my lord, the police authorities, my lord.
No,
in spite of
matters are coming without hearing private respondents.
my lord, difficulty is this, my lord. Why, my lord? My lord, I am submitting.
Come back on 30th April.
30th, my lord. My lord, the
If private respondents are represented, I am ready to
we
hear.
sent, my lord, we come back, my lord, that they are left without address.
What can be done?
My lord, because, my lord,
If all parties are not present.
Yes, because of the, my lord, they are proper parties, my lord, kindly consider mainly our grievance is against, my lord.
No, if
police
Mr.
authorities.
Maiti, private respondents are not represented today, I cannot take up this matter. Because in other matters, I have adjourned.
Only today, my lord, yes. My lord. Because, my lord, they are all Bangladeshi people, my lord. Their name has been struck off from the roll in the SIR.
They have a right of audience before this court.
Yes. So that's why, my lord, because of this resolution, your lordship is not.
Otherwise, I could have taken up.
Yes, my lord.
If service is complete, there is no difficulty in taking up this.
But, my lord, they have left without address. This is the postal remark, my lord.
Well, come back on 30th.
30th. Deep lord.
আচ্ছা শোনো, দুটোর সময় ডিভিশন বেঞ্চ আছে, বসবো, খবর দেবে যদি আসে।
Item number 14.
Why you are mentioning?
Item number 14. We have served the copy of the speed code. They were not found. So my lord, I am taking pardon.
Yes, yes.
Have to serve the copy to the state by speed post, but they were not found. We were having
Let
to
it
serve the copy.
appear. By that time you try to serve. Today I will not pass any order regarding service.
Please, madam.
Nothing. You try to serve by this time. Let it appear in the list on the next day.
We want to order the sir.
one mistake on my part, for which I tender my unconditional apology. My lord, today's
Why you are mentioning? This is a
my lord,
different
today's
bench.
this, my lord, item
Sorry, please
45,
don't
my lord,
mention.
your lordship was pleased to fix.
Sorry, it is not
38,
a
my lord.
bench
My lord,
to
I
mention
know
this
it's not a
matter.
mentioning time.
Please don't mention. Sorry.
My lord, I was engaged in court number.
Sorry,
14.
sorry.
My lord,
Sorry,
the
mention on
matter will
Monday.
be infectious, my lord.
Mention on Monday. This is a different bench. Yes, please call the list.
Item number 1.
Lordship, I am appearing for the arrest contempt, Your Lordship.
My lord, as per your lordship last day's direction, I have served notice.
Yeah,
on
sure.
the appearing.
I'm appearing, Lordship. On the basis of my instruction, Lordship, we complied with the Lordship's order, Lordship. And Lordship, can you allow us to file the compliance report on the next date, Lordship?
Very well, in that event, if it is the stand up the alleged contempt that the order is complied with.
My lord.
In that event, you file an affidavit of compliance.
My lord.
May I indicate to your lordship how, I don't know how they are saying affidavit of compliance. The direction of the learned single judge was that pay them entire benefit like all other teachers. Now, we were appointed at a point of time when the classes 11 and 12 were given to higher secondary council instead of colleges.
Higher secondary council?
Instead of colleges. 11, 12 were
Instead of?
College.
Colleges.
There was a time. Therefore, there was certain requirement of so many teachers. We were recruited in a special drive with all academic qualifications as necessary in respect of normal appointment. But we had to take only 10 classes per week. The annual salary was also very little. Now, in course of time, this was during 2000, 2002, like that. In 2010, government circular was issued that you have to take normal classes as the regular teachers, the regular number of classes. And then you will be entitled to leave. Now, we started without taking regular classes, more than 20 classes per week, as was done by the normal teachers. But this continued.
Now, Mr. Gupta, in the contempt, we are not required to enter into this thing. Please take me to the relevant part of the judgment.
I will take 2 more minutes.
Petitioner applicants is violated. Please take me to the relevant part.
Just 2 more sentences.
Honorable Supreme
Just
Court.
2 more sentences. After that, in 2013, they said you don't have to take so many classes because they said that we are started making agitation, they give us more pay.
You stick to 10 classes.
Stick to 10 classes in 2013. But the schools had no other alternative. There was acute shortage of staff. We were taking regular classes throughout for decades. And this went on. We filed this petition, and the single judge said you are all these persons taking regular classes like normal teachers, pay them equal pay. The division bench altered the judgment in lieu of Jagdish Singh Supreme Court judgment, the 2017 judgment. What was the judgment?
Basic pay.
Basic pay.
I remember.
Exactly. The basic pay.
Only basic pay, regular basic pay to be paid.
Basic pay, and that's also the minimum stage of the basic pay. Therefore, you have the division bench direction, compliance of that. Now,
please indicate the relevant part of the judgment,
kindly,
which according to you is violated.
Page 41 judgment starts.
Yes, judgment starts at 41. It's a judgment dated 3rd September.
Kindly come to page 72.
Page 72.
Lordship.
Yes.
72 last paragraph starting but for the period. But for the period earlier to 2010, we are unable to arrive at a definite conclusion on the basis of the materials on record that the institutions have discharged same or similar duties of a regular teacher in the respective institutions. However, it is left open to the institutions to apply before the Secretary of School Education in justification of basic pay for the period from 2007 to 2009, demonstrating discharge of similar duties as of a regular teacher for the said period. Mr. Gupta has made a passionate argument with regard to the entitlement of petitioners post 24th December 2013, by which, therefore, this 2010 to 2013, there was no dispute. We had taken regular classes, by which previous government order dated 2010 was withdrawn. Mr. Gupta submitted that in view of the disclosure made in the supplementary affidavits showing that the petitioners have been discharging duties similar to that of the regular teachers, notwithstanding the memo dated 24 December 2013, the government as a model employer should extend suitable benefits to the teachers who are sincerely and devotionally performing their duties. Although our heart is with the center. Then kindly take the next paragraph. Under such circumstances, we modify the order of the Secretary by directing the appellant to make payment of salary equal to basic pay in the pay scale of pay of regular teacher working in higher secondary section in a non-government aided higher secondary school with effect from 28 July 2010, during the date of the order which is quoted above, till 24/12/2013, when the previous due dated 28 July 2010 should be withdrawn under due date 2013.
That is the crux of the.
No, that is the period for which payment has been made. That part is complied with.
Because, just a minute, under the
10 to 13.
Just a minute, Mr. Another. 10 to salaries. So this has been complied with.
This 10 to 13 complied with.
Yes.
But the other DSN is 2007 to 2010 and 2013 and onwards. Regarding that, the state government also restrained any further appointment of any new part-time teachers on contract basis in non-government aided schools with effect from 1st April 2020. This area salary shall be paid positively within 4 weeks from date. In the event the persons make a representation before the Secretary in justification of basic pay for the period April 2007 to December 2009 and after 24 December 2013, demonstrating discharge of similar duties within a period of 4 weeks after the lockdown is relaxed and the normal functioning of the school and college has restored, the Secretary shall consider such representation within a period of 3 weeks thereafter upon giving an opportunity of hearing to the petitioners as well as concerned schools. The representation can be sent, etc. Now, it is needless, a few lines, 2 lines later, it is needless to mention that the COVID protocol in place on the date of hearing shall be strictly followed. The school authorities shall be under an obligation to produce the attendance register and the class routines for the aforesaid period before the Secretary of School Education, along with any other materials as may be directed, in order to enable the Secretary to decide the claim of the petitioners. It is needless to mention that the Secretary shall be guided by the principle laid down in this order and shall not deny the claim of the petitioners merely because their initial contextual appointment, in view of the fact that the School Education Department had taken a decision not to sanction the additional processes. Therefore, for this period of 2007 to 2009 and 2013 onwards,
Just a minute.
এখান থেকে ফাইন্ডিং 26 ফাইন্ডিংস ট্রান্সফার
দেখেছি 5 and 6 5 and 6 5 and 6
টেস্ট না করি অর্ডারটা
করতে যাবো আগে প্রথমে করতে যাবো
দেখি 36 ফাইন করতে যাবো needless to mention সেটা 229 paragraph eta. So এইটা is true. Contrary to page 66.
Now, whether the secretary has not passed any order.
Lordship. Yes, kindly
Secretary
come
passed
to
the
page
order.
226. Now, therefore, the judgment says that don't deny them the benefits of this judgment only because their initial appointment was contextual. Find out from the grassroots.
But Mr. Gupta, if the order is passed by the secretary, then how the
Milord,
content is
I have brought
how
judgment.
the court can this court can come to a conclusion that there was
Yes.
deliberate
That's a
content,
very pertinent question. Milord.
willful and deliberate violation.
That's a very pertinent question. I have come with an answer
So
for that.
J.S. Parihar,
Yes. After that, Milord, I said
rightly or wrongly, secretary
such
has passed an order.
no.
But
That's
how
what
the contempt
Milord, the
petition
Pratihar,
is maintainable, then it can give at very best it can give rise to a fresh cause of action.
Milord, it will not here. Why I have dropped judgments in support of my contention. I should show it. Milord, here the specific direction is decide issue number 1. What is issue? That issue 2007 to 9 and 13 onwards, whether they are entitled to pay, and for that consider what?
Very well. Mr. Yusuf,
Lordship.
you file an affidavit of compliance
My lord.
enclosing the order of the secretary.
But I
Requesting
have
the
annexed it.
court
I have
request.
annexed it.
So let them
Compliance,
take,
compliance
file an
report. And
affidavit
Lordship,
of
this matter also went to the Supreme Court and Supreme
yeah, that is separate aspect, but
Lord.
Supreme Court did not
directed to the principal secretary to consider the representation of the petitioner. We considered it and passed a reasoned order that is appearing in the last page or last annexure of this.
Where is the order
petition.
of Supreme
Milord, kindly.
At least 226, Your Lordship. Supreme Court orders, Lordship.
No, Supreme Court.
At page 76, Your Lordship.
So Supreme Court modified the order? No.
226 was the reason order.
Supreme Court says that it is deemed to appropriate to direct the state government of West Bengal to.
No, where is the order of the Supreme Court? This is a reasoned order. 15 January 2025 is the reasoned order of the Secretary School Education Department.
Yes. January 2024, Lordship.
Yes.
Page 76, Your Lordship.
Page 76.
That's a Supreme Court order.
Petition was dismissed.
78.
Appeal was dismissed.
78, kindly come to 79. Middle of page 79.
I'm reading from the page 76, Lordship. It is deemed to appropriate to direct the state government of West Bengal to make compliance of the impugn judgment within a period of 3 months.
Page 79.
Yes, 79 middle.
Page 76, just
Starting from the page
Just
76.
So Supreme Court directed to implement the order
Lordship.
by taking decision.
We had considered it and
So therefore,
considered.
doctrine of merger will not apply.
No.
Now, you have taken a decision as it is in page 226.
286.
226.
226, 226, Lordship. From 226. Reason order passed, Lordship, at annexure A.
Division joint judgment, the principle laid down is find out from class routine how many classes they have taken, decide on that basis. What they do is they go into a question of equal for equal rights like this.
Whether the school authorities were not provided opportunity to file class routine.
Exactly, they did. But the decision was not based on that at all. The decision is based as if that single judgment is being considered. For equal work, that principle will not apply.
Mr. Gupta, as it appears to us that there are two parts of this order. First part is page 73 payment of salaries equal to basic pay in the scale of pay of regular teachers working in higher secondary section in a non-government aided higher secondary school with effect from 28 July 2010 being the date of the order which is quoted above till 12 December 2013.
This part is
This
compliant.
part is complied with and the payment was made by fixing the pay of the petitioners
At the bottom of the
at the
scale.
bottom of the
Scale.
pay structure considering the relevant basic pay.
No dispute with regard to 10 to 13.
With regard to arrear pay.
No. With
If
regard,
petitioners work.
yes.
If petitioners work.
Now, for that, school is directed to produce the
Arrear salary, this starts from the last line of page 73 of your contempt application. It says that the arrear salary shall be paid positively within 4 weeks from date. No, that is in connection with payment up to 24th December 2030.
Also, arrears also be paid to lordship.
In the event, it starts from the last two words, page 73. In the events, the writ petitioners made a representation before the Secretary School Education Department.
That was done.
Basic pay for a period of so and so. Then the procedure is laid down that how it is to be representation is to be made. It is needless to mention that the COVID protocol, then the school authorities shall be under the obligation to produce the attendance register and class routine of the aforesaid period before the Secretary School Education Department along with any other materials may be directed to. It is needless to mention that the Secretary shall be guided by the principle laid down in this order and shall not deny the claim of the petitioners merely because the initial contractual appointment in view of the fact the School Education Department had taken a decision not to sanction additional posts for these higher secondary schools which were running with the part-time contractual teachers since 2002 with effect from 1st of April 2007. So consideration is that the Secretary School Education Department shall pass an order after deliberation or representation by the petitioners. Now, while taking such decision, Secretary shall take into consideration the classroom routine and the attendance register if those are placed before the Secretary. Now, those are placed.
Yes.
Now, if it is found to the Secretary to the petitioners after the decision was taken by the Secretary School Education Department on 15 January 2025 that this is a wrong order since attendance of the petitioners at the relevant period of time for consideration of payment of arrear dues was not considered, then whether contempt will lie?
Because I have brought judgment of this court, which says, my lord, after Petitioner, that where there is a clear circumvention, intention to circumvent the order. Now here what has been clear circumvention is arising for this reason. Division 1 says you follow this guideline. What is that? Find out actual classes taken, number of classes taken, and make your decision the only basis. That should be the only basis for the decision. Not the
that is not the decision, Mr.
Yes, ma'am. Yes, kindly take this. We are kindly see.
Yes, let us come to page 74.
74.
We have dealt in paragraph 5 and 6 of the recent document.
It is needless, page 74 towards the end, last 6 lines. It is needless to mention that the Secretary shall be guided by the principle laid down in this order. What is that principle? Following Jagdish Singh, that pay give them the pay of the last minimum of the last basic pay of the basic pay.
It is needless to mention that the Secretary shall be guided by the principle laid down in this order and shall not deny the claim of the petitioners merely because of their initial contractual appointment.
Yes.
That is the principle.
That's the principle. No, two aspects. One is
yes, it is to be read as a whole.
Exactly.
What is the principle? That it is needless to mention that the Secretary shall be guided by the principle laid down in this order and shall not deny the claim of the petitioners merely because their initial contractual appointment in view of the fact that the school education took so and so decision.
One
that is not in consideration of that on court directed that the Secretary School Education Department shall take a decision on the basis of the routine and attendance registers which shall be submitted before the principal secretary or secretary school education department. This was submitted. A decision was taken. Now that is not there is no such hard and fast direction by the coordinate bench that that to come to a specific conclusion with regard to attendance.
My submission is that this was a specific direction. Why I said this? Kindly come back. There are one positive, one negative factor of consideration. It is needless to mention the secretary shall be guided by the principal laid down here, and shall not be.
Let us not stop here. It is needless to mention that the secretary shall be guided by the principal laid down in this order and shall not deny claim of the petitioners merely because of their initial contractual appointment.
Yes, therefore
in
there
view of
is
the fact that is the principle.
No, therefore there is a point.
That is the principle. Is it your case, Mr. Gupta, that that this principle which is laid down by the coordinate bench was not followed?
Was not followed at all.
No, but the principle is this, that the fact that the school education department had taken a decision not to sanction the additional post. This is the principle.
No, I mean, kindly pardon me. Because the principle, as I read it, kindly correct me if I am wrong. There is one positive guideline, one is negative. First is positive, that you take into consideration the principle we have laid down here. The principle, I shall take your lordship to that part of the judgment. The principle is, following Jagdish Singh case, that since they have taken some number of classes, pay them the minimum of the basic. That's the principle laid down in this judgment. Therefore, follow that. First, positive guideline. Second, negative guideline is...
What positive guideline you are saying?
Positive guideline is entitlement to receive minimum pay for taking same number of classes.
No. With the greatest of respect, certainly no. The court was considering arrear salary which is to be paid in the same methodology, following the same methodology which was directed by this court, that placing by fixing the pay of the petitioners at the bottom of the pay structure on a particular basic pay.
What is that?
That is that direction. Now, while giving direction, Mr. Gupta, court directed that yes, from 2000 up to 24th of December 2013, it is to be paid.
Why
So for the claim of arrear claim, a window was kept open that yes, you can make a representation that will be considered by the principal secretary school education department, provided school education department is satisfied that yes, they have put in service. Now, but the principle of equal pay for equal work, that was considered by the coordinate bench, and on being guided by that principle, coordinate bench directed, yes, pay the salary on a particular basic pay from up to 24th of December 2013. That up to this is certain. But so far the payment of arrear salary is concerned, it was directed, yes, a representation is to be made, and that is to be considered by the authority. And while giving direction to consider the representation, there was another observation that it is needless to mention that a secretary shall be guided by the principle laid down in this order and shall not deny the claim of the petitioners merely because of their initial contractual appointment in view of the fact that school education department had taken a decision not to sanction any additional post for these higher secondary schools which were running with the part-time contractual teachers since 2002 with effect from 1st April 2007. So if this is the observation came from the coordinate bench, then it cannot be said that if any order is passed that principal secretary school education department is required to follow the principle of equal pay for equal work. Following Jagdish Singh, that chapter is over. Today we are on the we are considering the contempt petition. In the contempt petition, You demonstrate that where is the violation.
Yes, I demonstrate that.
Yes.
Take page 236.
Yes.
Because equal pay for equal work, that principle laid down by the single judge was not
Modified.
accepted, was modified by the division bench.
Yes.
Division bench said no, not equal pay for equal work, no. Only the basic minimum, nothing else. Provided you have worked for the equal number of classes. Secretary proceeded on the basis as if he's asked to decide on the question of equal pay for equal work. That was not the decision of division bench, that was the decision of single bench. Secretary decided on the principle of equal pay for equal work and whether that principle will apply here or not. Kindly come to page 236. That was the single bench judgment. Division bench said no equal pay for equal work. Only the basic minimum, nothing else.
Yes, but where is the content? Where is the act of content?
Content is court says decided on point 1. Authority decides on point, leaving aside 2 to 2 and 100. They decide on different points.
I couldn't follow. Point. What is the point? So far, first part of the direction it is complied with. Second part of the direction, directing the principal secretary to take decision on the representation, decision is taken. Where is non-compliance?
Non-compliance is
applying J.S. Parihar for formula.
Yeah, but Party does not provide any formula. It says that
if rightly or wrongly authority has taken a decision, that will give rise to a fresh cause of action.
But
Mr. Gupta, we have learned from you.
No, but
Yes.
kindly consider one thing. If the authority says that I decided without any consideration, that's also decision.
Yes.
If the authority says I deny them benefit without taking into consideration any aspect, that's also a decision.
I denied benefit
without taking into consideration any factor. And the close that.
No, the factor which was directed to be considered is not coming in your aid to constitute before or to make out a case of contempt. Because this is the only factor, Mr. Gupta, which was directed to be considered by the principal secretary is this, that shall not deny the claim of the petitioners merely because of their initial contractual appointment. Whether they were initially appointed on contractual basis was the reason for denying your benefit.
Exactly. That is what has been done. Let us see. Kindly take page 236.
Yes, let us see.
236.
Okay, it will be better.
Come to paragraph 9, at page 236.
236.
Part of the reason. Part of the written order. Paragraph 9. Having considered the facts and circumstances of the case, judgment records, submission of parties, and the law applicable thereto, it may be observed that the quality of work varies and depends upon the qualification, workload, experience, etc. that a professional handles during his service years. There are numbers of instances of doctors, advocates, or professionals from other fields, including education, who charge higher than that of others in the same field. The higher fees of pay remuneration depends on the quality of work and the reputation they earn by rendering such quality work over the years. The quality of work of a contractual teacher who was engaged by school committee for some limited number of classes only in her second section cannot be equated with the volume and
page
quality.
236. Page 236.
Yes.
Yes, paragraph 9A.
9A.
Yes.
The quality of work. The quality of work of a contractual teacher who was engaged by school committee for some limited number of classes only in her second section cannot be equated with the volume and quality of work rendered by regular teachers who have entered the service in regular. So this is your then B.
Equal pay for equal.
You are contractual, not regular, therefore no.
I also give trouble to your lordship to see the paragraph 5 and 6.
Then we are, I said place the order. Kindly come to B then. B. Middle of B. At page 236, middle of B. Principle of equal pay. middle of page, last page, principle, logic and logic mirror, principle of equal pay for equal work cannot apply unless there is complete and wholesome identity between the two groups. There are special differences between part-time teachers working as contractual basis and regular teachers of the government aided school. The whole emphasis is on contractual appointment. Therefore, you don't get. Then you are C.
Yes, please come to page 236.
236, Lordship.
9B.
P, Lordship.
The part-time teachers engaged in different higher secondary schools in higher secondary section are in a different footing than on the regular teachers of a government-aided higher secondary schools. No one who is in different footing can claim equality under the Constitution of India. But this was not the consideration, or this was not the issue which was required to be considered by the principal secretary.
Pass this order, can you, Lordship, consider the paragraph 5 and
Because
6?
it has been made specific by the division bench that on the principle or as it has been pointed out by Mr. Gupta, that if you come to page 74, that it is needless to mention that the secretary shall be guided by the principle laid down in this order and shall not deny the claim of the petitioners merely because of their contractual appointment.
Lordship.
So why this was the consideration? Because contractual appointment ought not to be a consideration for denying the right of arrear salary. If it is found they have rendered service for the relevant period.
My Lord.
So why this was the consideration? This was negated by the honorable division, by the coordinate bench.
But Lordship, we have considered the entire aspects, Lordship, in paragraph and 5.
But can this issue be reopened? This was not open to the alleged contemptor or the Secretary School Education Department to go into the issue of eligibility of the petitioners to claim arrear salaries, since they are appointed, or rather they were appointed on contractual basis. Because that door is closed by virtue of the order passed by the honorable division bench.
Sitting in appeal.
Lordship. Then why this was the consideration?
Paragraph A, B, C, D, everywhere.
Whole hog you cannot consider the issue as it is an entirely open case. You have to consider the case in view of the directions passed by the court, where these are the considerations which are not permitted in consideration, taking note of the judgment of the coordinate bench dated 3rd September 2020. How that is permissible? Yes.
Thereafter,
simple thing.
We don't want
to expand the scope. Please come to again.
Lordship,
come to page 74.
Lordship, one thing. Thereafter, this order was also once again went to the Supreme Court, and Supreme Court confirmed this order. I am placing this order, which was passed on 6 January 2026 this year, Lordship.
Which order was
this is some of the intervener, and pleader moved the Supreme Court for
after this order was passed by the
after this order, Lordship, after this order. Group Adha Bera was one of the intervener and pleader in this matter, Lordship.
এটা was not something এটাতে হয়েছিল কি যে কয়েকজন কি আমাদের জন্য আলাদা রিজন অর্ডার পাস করে হ্যাঁ এখানে নেই আলাদা হয়েছে
Paragraph 8 and 9 is important, Lordship, to consider.
Public matter the election by the authority to pass separate order for separate persons. The dispatch facility by phone duly granted by the Supreme Court not extended to
I shall explain this.
Just a minute.
সেটাই বলেছিল যে অনির্বাণের অর্ডার উইল অ্যাপ্লাই টু অল, সেটা সুপ্রিম কোর্ট বলো না, আলাদা আলাদা ডকুমেন্ট ইট ইজ লাইক
এটা বলতে আপনার কি হয় বলেছে আপনার কি হয়
এখানে না না এটা এখানে বলে
হ্যাঁ
মানে সেক্রেটারি বলেছিল অন্যদের ক্ষেত্রে similarly prescribed, including
ঠিক আছে
সেখানে ওরা সেপারেট প্রেসেন্ট অর্ডার পাস করে।
এখানে হিয়ারিং দিতে হবে কোথায় বলছে এখানে হিয়ারিং দিতে হবে হিয়ারিং দিতে হবে
Justification
না না
the opportunity of upon giving an opportunity of hearing to the writ petition, upon giving opportunity of hearing to the writ petition, that was not extended to other petitioners or interveners. As well as the concerned school, the school ke uthai.
এটাই দেখাচ্ছে তো হ্যাঁ এত মোটা তো দেখতে
এইটা একটু দেখুন। আমি petitioners were not granted. Petitioner guru কিন্তু
এইটা তো তাই রয়েছে এই তো নো এই তো আমি আগে অ্যাকাউন্টে
এইটা হচ্ছে ইন্টারফেয়ারেন্স
এরকমটা হ্যাঁ ঠিক
reason for order was not the subject matter.
This is doctrine of merger will apply.
Please,
Please come to the order from paragraph 11 onwards, Mr. Gupta.
before that, kindly read paragraph 4. The petitioners allege that despite specific directions,
Petitioners মানে এখানে interveners.
these are they are interveners, not us. The petitioners allege that despite specific directions issued by this court, relief granted by High Court and subsequently affirmed by this
Yes, considering this case made out, please come to paragraph 11 onwards.
Yes. Now, just before that,
Please come to paragraph 11 onwards. Mr. Gupta, please.
I'm on 11 itself.
Yes, please come to paragraph 11.
11 is very relevant.
Let us read together paragraph 11 onwards.
Learned senior counsel Gopil Siwal fairly considered that the petitioners were not granted. Who is the petitioners here? They are interveners, not the petitioner before the judgeship. Petitioners were not granted an opportunity of hearing in terms of the directions issued by the High Court. High Court said give them hearing. That was not done, and their counsel, the state counsel admitted the hearing was not given. Fairly he submitted it, as explained by this court. Nor were the records of the concerned schools called for deciding their representations. That is not so in our case.
Maybe, but you are similarly circumstanced.
No.
And there, but let us go back to the order passed by the Supreme Court. Relief granted in the said judgment shall also be extended to all similarly placed private respondents, including interveners, impleters, who have moved the applications in the present petition.
Now, what is that?
So, therefore, the petitioner's case, applicant's case before us, or the writ petitioner's case, as well as interveners and impleters' case was considered, and an order was passed on 16 July 2024. Some of the parties who claiming to be the beneficiary of this beneficiaries to this order dated 16 July 2024 approached the Honorable Supreme Court. Honorable Supreme Court passed an order
6 January 2026.
On 6 January 2026, directing that yes, you revisit the issue, not revisit, that was not in the steps taken by the authority was not in consonance with the directions contained in the judgment dated 3rd September. Therefore, and it was fairly considered before the Honorable Supreme Court on behalf of the state respondents that no opportunity of hearing was not granted, records were not called for from the respective schools. Therefore, let these steps be taken and matter to be heard. Now, then the entire issue needs to be considered in terms of this order. We cannot pass an order ignoring the order passed by the Honorable Supreme Court on 6 January 2026.
That order does not apply to me. I am an individual. In my case, the judgment is passed. The Supreme Court said that the same judgment should follow other cases. And in my case, we were called for hearing. In other cases, they were not called for hearing. Supreme Court said give them hearing also. How are we concerned with that?
They are the completely similarly circumstanced in view of the order passed by the Honorable Supreme Court dated 16th July 2024. Because in paragraph 2, last part of paragraph 2, it was observed by the Honorable Supreme Court that a relief granted in the said judgment shall also be extended to all the similarly placed private respondents, including the interveners, impleters, who have moved the applications in the present case.
Exactly.
Now, all other parties, interveners and impleters, they were granted same benefits. Now, say there are 100 beneficiaries to this particular
judgment.
order of the Supreme Court dated 16 July 2024. Some are the petitioners, some are impleaders, some are interveners. Now, some of the candidates went before the Supreme Court, and Supreme Court passed a subsequent order on 6 January 2026. Now, why this order will not apply in case of others?
Because in their case, the grievance is totally different. In my case, our case is considered.
Court also referred on the paragraph 2 about the state of West Bengal versus Anirban Roy. Paragraph 2, Lordship, referred this case also. Obstructor has recorded, Your Lordship.
That's the basis.
The state of West Bengal and versus Anirban Roy. He has taken this record on this matter also, similar matter.
He said
The state of West Bengal.
passed a recent order between, but in our case, we have not passed a recent.
They say in Anirban, that is my matter, you have passed a recent order. In our case, we have not. Upon giving hearing, but in our case, no such thing done. How is it connected?
It is wholly connected. It is wholly connected, Mr. Gupta.
Kindly visualize one thing.
Contempt does not lie.
Kindly visualize one thing. In my case, the inaction is a different nature. Namely, we are called for hearing, our records duly called for, but they don't.
First of all, court directed, coordinate bench directed the Secretary School Education Department to take decision. Decision has been taken, give rise to fresh cause of action. Now there are only one observation which you are harping on, that particular observation, that principle to be followed. But our judgment of the coordinate bench traveled to the Honorable Supreme Court, and Honorable Supreme Court directed no, follow the judgment of the division bench dated 3rd September. And there were interveners, impleaders. They were also directed. It was also directed that they will get the benefit of the order passed by the Honorable High Court. High Court. It is specifically observed that yes, the relief granted in the said judgment shall also be extended to all the similarly placed private respondents, including interveners, impleaders, who have moved the applications in the present petition. Now, out of these beneficiaries to the judgment dated 3rd September of the coordinate bench, some of them approach again Supreme Court by filing a contempt petition. Now, this contempt petition, Supreme Court directed, yes, you revisit the issue after compliance of these formalities. Now, why this will not apply in your case?
Kindly note this. Supreme Court did not say the reasoned order will apply in your case. Supreme Court did not say that. Because our stand, our case for contempt and their case for contempt lie on totally different aspects. We say that what the High Court...
What will happen today if this court hold that this is a contempt, and on the face of contempt, this on the threat of contempt, or on by issuing contempt rule, if the contemners grants this benefit of arrears salary to the petitioners, then what will happen to the directions
That
passed by the
depends on
Supreme
the
Court?
number of...
Then this will create a further complication that similarly circumstanced candidates will go to the Supreme Court and say, in spite of this order passed by this passed by the Honorable Supreme Court, the division bench of the High Court has passed this order. Therefore, we are entitled to get the similar benefit. No, Mr. Gupta, please come. Sorry. Contempt application is heard at length in presence of the learned advocates representing the applicants. Oh, representing one applicant has come, representing the applicant and alleged contemners.
Just two applications, Lordship, 1 and 2. 1 and 2. Both matters are appearing, Lordship.
Yeah, there are two matters. Yes.
And order isn't order also passed by.
Let me pass an order on the first petition. Wait. Alleged contemner. Stop. Next paragraph. Mr. Lokhi Kumar Gupta, learned senior advocate, represents the applicant and submits part of the judgment delivered by the coordinate bench on 3rd September 2020 on two intra-court appeals, one being MAT 1221 of 2019 State of West Bengal, within bracket, State of West Bengal and others versus Anirban Ghosh and others. And another being MAT 1367 of 2019, within bracket, State of West Bengal and others versus Borun Kumar Ghosh and others, close bracket. এই ইয়েকেও একটু ডেকে নাও, আমাদের শুভেন্দুকে একটু ডেকে নাও। Borun Kumar Ghosh and others is violated. Stop. It is tenuously argued on behalf of the applicant in order to demonstrate before this court that the order passed by the alleged contemner dated 15 January 2025 is not in consonance with the directions as contained in the said judgment dated 3rd September 2020, passed by the coordinate bench. Stop. It is contended on behalf of the applicant that judgment dated 3rd September 2020 had two facets. One is direction upon the concerned respondent authority to pay salaries equal to basic pay in the scale of pay of regular teacher working in higher secondary section in a non-government aided secondary school with effect from 28 July 2010, being the date of the order now being the date of the order 28 July 2010 till 24 December 2013, when the till 24 December 2013. Stop. The coordinate bench also granted liberty to the petitioners to make representation before the alleged contemner seeking payment of arrear salary at the same rate which was directed vide said judgment dated 3rd September 2020 for the period from 28 July (2010) till 24th December 2013. In the event they were found to be entitled on production of records of the respective schools before the concerned production of records of the respective schools relating to their attendance for the relevant period. Stop. It is contended on behalf of the applicants that though alleged contemner passed a reasoned order on 15 January 2025, but the principle which was required to be adhered to in terms of the judgment dated 3rd September 2020 was not followed, which tantamounts to willful deliberate violation and an appropriate and an appropriate order may be passed on this contempt application by issuing rule. Stop. Drawing our notice to the relevant part of the judgment dated 3rd September 2020, it is also submitted. It is also elaborated that the coordinate bench specifically observed that merely because petitioners are working, now that merely because petitioners, plural apostrophe, petitioners initial merely because petitioners were initially appointed on contractual basis, that would not negate their claim of arrears salary, but in contradistinction thereto, while passing reasoned order by the coordinate bench, reasoned order by the alleged contemner dated 15 January 2025, initial contractual appointment of the petitioners was considered to be one of the grounds in denying their entitlement to receive arrears salary, which is contumacious act on the part of the alleged contemner. Next paragraph. Mr. Yusuf, learned additional government pleader, has drawn attention of this court order passed by the Honorable Supreme Court dated 16 July 2024 on a special leave to appeal within bracket civil close bracket number 14355/2021 within bracket State of West Bengal and others versus Anirban Ghosh and others. Along with another special leave to appeal within bracket civil number 2809/2021 and transfer petitions number 1288-1297/2022. Video order dated 16 July 2024. Special leave, aforesaid special leave to appeal, aforesaid matters were dismissed by the Honorable Supreme Court. And state government and the state and concerned and state government and government of West Bengal was directed to comply the impugned judgment of the coordinate bench within a particular time. Stop. It was also within a particular time. Stop. Reliance is also placed on the another order of the Honorable Supreme Court dated 6 January 2026, passed on contempt petitions, whereby Honorable Supreme Court in paragraph 11 onwards paragraph 12 onwards specifically observed specifically granted liberty to the petitioners to submit fresh representation before the alleged contender herein, or to submit fresh representation before the Secretary, School Education Department within a specified time, and on receipt of those representations, Secretary, School Education Department on taking certain steps was directed to pass a detailed reasoned order on consideration of the representations and submissions to be advanced on behalf of the petitions. Stop. It is submitted on behalf of the alleged contender that if the contempt applicants in those contempt petitions which were disposed of by the Honorable Division Bench, Honorable Supreme Court, vide judgment dated 6 January 2026, are similarly circumstanced like the present petitioners. Stop. Therefore, present petitioners are required to be similarly treated in terms of the order dated 6 January 2026. Next paragraph. Mr. Gupta, learned senior advocate representing applicant in the present contempt petition, submitted that the applicant was not a party. Applicant was not a party in the contempt applications which were disposed of by the Honorable Supreme Court, vide order dated 6 January 2026. Therefore, said order does not bind the applicant, and it is open to the applicant to make out a case by filing a contempt petition that one part of the judgment dated 3rd September 2020, whereby alleged contemptor was directed to take decision on the entitlement of the applicant to receive arrear salary. Sentence type of bolo to. Therefore, it is open to the is violated as
In our case, this has been done.
steps were not taken by the said alleged contemptor following the principle set forth in the said judgment of the coordinate bench dated 3rd September 2020. Next paragraph. Having considered the rival submissions made on behalf of the parties and taking note of the judgment of the coordinate bench dated 3rd September 2020, as well as the judgment slash orders of the Honorable Supreme Court dated 16 July 2024 and 6 January 2026 passed in contempt petitions. It is found that after the order was passed by the Supreme Court by the Honorable Supreme Court on 16 July 2024, it was open so far the present court is concerned to consider act of violation of the judgment dated 3rd September 2020 as the case made out in the present contempt application, to the extent of taking decision by the alleged contemptor on the representation made by the present applicant seeking release of arrear salaries. But the situation is altered after the order was passed by the Honorable Supreme Court on 6 January 2026 on contempt petitions of similarly circumstanced other applicants, similarly circumstanced other candidates. Stop. On the contempt, while disposing of the contempt applications of other candidates, similarly circumstanced other candidates, by passing order on 6 January 2026, Honorable Supreme Court granted fresh liberty to the applicants therein to submit representation before the Secretary, School Education Department within a period of 6 weeks, raising their grievances / claims / entitlements in terms of the order passed by the coordinate bench on 3rd September 2020. Stop. Secretary, School Education Department was directed to afford an opportunity of hearing to the petitioners in representative capacity, either in person or through legal advisor or advocate. Records lying in the schools were directed to be called for. Prior to the hearing, and opportunity was granted to the candidates to inspect those records. Stop. Finally, the Secretary, School Education Department was directed to pass a detailed reasoned order on consideration of the representation of the applicants in those contempt applications, in those contempt petitions which were disposed of by the Honorable Supreme Court. Mr. Yusuf, after this order was passed on 6 January 2026, Secretary, School Education Department passed order on 15 January 2025.
My lord.
So therefore, you are required to initiate a fresh proceeding in terms of the order of the Honorable Supreme Court.
Lordship.
Because the reasoned order which Mr. Gupta has relied upon is dated 15 January 2025.
We already started, Lordship.
So there also the petitioners will be given opportunity.
We have not received any notice. We have not received any notice. But all that doesn't concern us. No notice has been sent to us. And our representative was dismissed, was already disposed of.
Lordship, we will issue that notice. We will issue. Yeah, Lordship.
And our
Next paragraph.
We have issued all notices to all the who met the representation, Your Lordship.
A present applicant shall also be at liberty to make a representation before the alleged contemner as
Kindly fix the timing.
opportunity was granted to similarly circumstanced candidates Video order dated 6 January 2026 by the Honorable Supreme Court. Stop. If such representation is made by fortnight from date, same shall be considered along with similarly circumstanced other candidates whose contempt applications were disposed of video order dated 6 January 2026. Next paragraph, it needs to be recorded herein that all the similar issues, it needs to be recorded herein. It needs to be recorded herein that the case of the present applicant as similarly circumstanced other applicants who approached the Honorable Supreme Court cases are required to be decided by the Secretary School Education Department uniformly, taking note of the observation made by the Honorable Supreme Court in the order dated 16 July 2024, while dismissing special leave petition of the state of West Bengal, which was preferred against the judgment dated 3rd September 2020 of the coordinate bench, comma, full stop. This court finds it appropriate to relevant part of the said order dated 16 July 2024 runs infra page 76 77 paragraph 2 টাকে paragraph 1 and 2 টাকে কোট করে দেবে 76 77 আর এই যে relief granted in the judgment shall also be extended to all the similarly circumstanced similarly placed private respondents including the interveners impleaders who have moved the applications in the present case. এটার নিচে আন্ডারলাইন করে নিচে করবে emphasis supplied এই পার্টটা হ্যাঁ It was made clear by the Honorable it was made clear by the Honorable Supreme Court in the said order dated 16 July 2024 that similar relief shall be granted to the interveners / impleaders, including private respondents, who moved applications in connection with special leave petition preferred by the state of West Bengal. Next paragraph. After the order passed by the Honorable Supreme Court disposing of contempt petitions on 6 January 2026, if two separate parameters are set forth for consideration of representations of similarly circumstanced candidates, it would create a class within a class, or it would create two different classes of candidates. That is not advisable, since it was found by the Honorable Supreme Court in the judgment, in the order dated 16 July 2024, that private respondents, interveners / impleaders are also entitled to get identical relief as it was extended to the respondents in the in two appeals, two intra-court appeals, which were disposed of with a judgment dated 3rd September 2020 by the coordinate bench. Next paragraph. Before parting with, we also find it necessary, we also find it relevant to record that the violation of the judgment dated 3rd September 2020 is made out in the present contempt application after the rescind order was passed on 15 January 2025 by the alleged contender. On the plea that the observations contained in the judgment dated in the said judgment dated 3rd September 2020 was not followed while taking such decision on 15 January 2025. But it appears to us that in terms of the said judgment dated 3rd September 2020, rescind order was passed on 15 January 2025 by the alleged contender, rightly or wrongly. Stop. Passing of such rescind order dated 15 January 2025 by the alleged contender ought not to be construed as an willful deliberate violation. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court. J.S. Parihar, Mr. Gupta, 1996 Supreme Court.
1996 6 SCC, my lord, page 291.
1996?
Para 6, yes.
1996?
1996 6 SCC, I will get it.
1996 6 SCC?
291, my lord. Para 6.
J.S. Parihar versus?
Parihar versus, my lord.
Well, I'll find it out.
Ganpat Dugar.
Ganpat Dugar, right. Ganpat Dugar. Stop. Next paragraph. In view of aforesaid, stop. Next paragraph. Next paragraph. With the aforesaid directions and observations, present contempt application is disposed of. Since I have directed the authority to consider the case of the applicant along with other applicants in the contempt applications which were disposed of by the Honorable Supreme Court.
In like manner. We have only gone through kind of in passing order on such representation, they will not be guided by that order.
Yes. ওইখানে যেখানে ডিরেকশন দিলাম না যে টু ইট উইল বি লিবার্টি ওয়াজ গ্রান্টেড টু দ্য অ্যাপ্লিক্যান্ট টু মেক এ ফ্রেশ রিপ্রেজেন্টেশন, ওইখানে একটা জায়গায় করবে যে at the time of taking decision by the Secretary School Education Department, he will not be influenced by his previous order dated 15 January 2025.
I'm with you.
গুছিয়ে করো, তাড়াহুড়ো কিছু করার নেই, টেক টাইম।
I'm with you. If my judgment has said
Today I found this is the right day to dispose it off because my present determination, it will be very difficult on other day to find out time. Otherwise, I was thinking to give direction for filing of a affidavit of compliance. It will be a futile exercise. Subsequently, I realized.
only thing that it would have been disposed of much earlier if my judgment had said that.
And not only Mr. Gupta, there would be another difficulty. Today, if we keep the matter, this is not a regular bench.
Exactly.
Then if we keep the matter pending and fix it after summer vacation, then by that time that exercise will be over in terms of the Supreme Court. That would prejudice the present applicant.
I am really obliged to you.
Yes. Oh, there is another matter. There is another matter, right?
Similar matter. I didn't.
देखिए फाइल टा
Item number 2.
If you write it, got the same order.
Same order.
If you write it, got the same order.
Similar,
Similar.
completely similar issue.
Absolutely identical. This case is also disposed of on
Record and order separately. The contempt application being CPAN 481 of 2025 is taken up for consideration. Stop. Mr. Gupta, learned senior advocate representing the applicant, submits that the order passed in the contempt application, order passed today in the contempt application being CPAN 480 2025 shall cover the issue involved in the present contempt application. Next paragraph. Alleged contender is also represented by Mr. Yusuf, learned additional government pleader. Next paragraph. In view of the submission made on behalf of the applicant, present application is disposed of with a direction. Present application is disposed of. Stop. No.
the direction in the judgment will apply.
Present application is disposed of.
Covered by.
Now, in view of the submission made on behalf of the applicant, the order passed by us, in the today in the contempt application being CPAN 480 of 2025 shall govern the present case. Stop. The judgment and order, the order passed today on CPAN 480 2025 shall be retained on record, duly countersigned by the Assistant Register Court. Stop. The present contempt present contempt application being CPAN 481 of 2025 is disposed of.
So in view of the submission,
Matter
in view of the submission made by the applicant, as well as the response, because they say they will consider our representation. At the
No,
last
I
time,
have directed that this will govern the
not
present contempt. So
no, your Lordship said that in view of submission made by the applicant, on behalf of the applicant, we are saying this.
Acha. In view of the submissions made on behalf of the applicants
And
and the alleged contempt. ওইখানটা second matter. Yes, Mr. Sir.